Hi, my name is Henry Sloyan,
And my name is Brice Thompson.
and we're presenting on the landmark Supreme Court case Lemon v. Kurtzman that was decided in 1971.
I will be presenting the case overview, the parties of the case, and the court decision.
And I will be presenting on the facts of the case and the legal issues.
Case overview. Pennsylvania and Rhode Island adopted statutes where the state paid for components of religious education which incentivized teachers to teach secular courses to the students of these religious institutions under the Non-Public Elementary and Secondary Education Act. This statute had upset taxpayers in both states, which they felt had provided them with grounds to sue. In both states, the cases were brought before district courts, in which both were to eventually be dismissed. This later drove the suing parties to appeal to the Supreme Court. This then posed the question, do statutes that provide state funding for non-public, non-secular schools violate the Establishment Clause of the First Amendment? The Supreme Court would find that state funding of non-secular schools would be unconstitutional through the indoctrination of the Lemon Test. Parties of the case. This pivotal Supreme Court case was spearheaded by appellants Alton J. Lemon and Joan DeCenso. Lemon represented citizens and taxpayers of Pennsylvania as he was directly affected having had a child in the public school system. DeCenso originally represented the taxpayers of Rhode Island as an appellee, but later joined Lemon as plaintiffs after both cases had originally been dismissed. David H. Kurtzman, who at the time was the superintendent of public schools in Pennsylvania, was the head appellee. Kurtzman was representing the Non-Public Elementary and Secondary Education Act, as he had wanted students of non-secular institutions to have access to the same curriculum as students of secular schools.
Now I will be presenting on the basic facts of the case. In 1968, Pennsylvania passed a statute that allowed for state funding for non-public school teachers in the form of paying for salaries, textbooks, and instructional materials for secular subjects. Most of this funding went to Catholic schools, and it was only paying for the secular part of the education and not for the religious part. This was brought to the attention of the district court by Alton J. Lemon and represented the citizens and taxpayers of Pennsylvania who believed that this was unconstitutional. The District Court of Pennsylvania dismissed this case. Similarly, in 1969, Rhode Island passed a statute that allowed for state funding for non-public elementary schools in the form of supplementing 15% of teachers' annual salaries. Again, they were paying for secular aspects of education and not for the religious parts. The citizens and taxpayers of Rhode Island, represented by Ms. DeCenso, was brought to sued and brought this case to federal court. And Alton J. Lemon, along with the citizens and taxpayers of Rhode Island, represented the appellants in this case, while David Kurtzman represented the Non-Public Education Act that Pennsylvania implemented in 1968. This case was ruled in favor of the appellants, Alton J. Lemon, and the other citizens of Rhode Island and the taxpayers as well. And this was decided by using a three-pronged test, now called the Lemon Test because of this case. We'll go into that more later on, but essentially this ruled that because it was more government involvement in religion, that it was a violation of the Establishment Clause of the First Amendment, and it was a violation of the separation of church and state. Next, I will be discussing the legal issues of this case. In the first place, this is a religious freedom assignment, and the case Lemon v. Kurtzman deals mostly with religion in its entirety. The question of this case is whether it violates the Establishment Clause of the First Amendment. The Establishment Clause of the First Amendment states that there shall not be a state-sponsored religion. So this is essentially just the separation of church and state. In Pennsylvania, the statute that paid teachers supplementing their salaries, giving them or paying for their textbooks for secular purposes, while this is a legal action, the fact that it is done in a religious setting makes it a violation of the Constitution. So For the Pennsylvania case, the direct state funding to a religious organization is under scrutiny. In the Rhode Island case, it has to deal more with the excessive government involvement with religion. So, like the Pennsylvania case, the statute that was implemented in 1969 allowed for the state to fund secular activities in religious schools. And all the complications that come along with this statute are the reason that it was brought to the Supreme Court. Citizens and taxpayers of these two states became very unhappy when they realized that a lot of their taxpayer money is going towards these efforts towards religious institutions. And the fact that most of these taxpayers have their kids in public schools creates a big problem. 95% of the schools that were funded by the state were Catholic schools. So essentially, in the state of Pennsylvania, it looked like they were sponsoring the Catholic religion and they were kind of pushing an agenda. And obviously people who aren't Catholic or who are not religious would be offended or displeased with this kind of legislature. Citizens and taxpayers of these two states worked with representatives to fight for their cause, and it eventually was brought to the Supreme Court, where it was ruled that it was in violation of the Establishment Clause of the First Amendment.
Court decision. The court would find it to be unconstitutional that the states provide government funding for religious institutions, as it had violated the Establishment Clause of the First Amendment. This would be determined through the indoctrination of the three-pronged lemon test. The court ruled that a statute must pass this test in order to avoid violating the Establishment Clause. The lemon test poses three questions. Does it have a secular legislative purpose? Does it foster excessive government involvement with religion? And does it promote or inhibit religion in any way? To answer the first question of does it have a secular legislative purpose, the court ruled yes. It was determined that the state statutes had been passed with the means to ensure that students of non-public schools were being given access to certain levels of secular curriculum. To answer the second question of does it foster excessive government involvement with religion, the court ruled yes. They ruled that the government was providing excessive state involvement in the affairs of religious institutions, which was determined based off of the amount of oversight that would have been necessary to ensure that the teachers of these non-secular organizations were not unnecessarily including religion with these secular subjects. The last question of does it promote or inhibit religion in any way actually went undecided. The court could not find whether or not that the statute was promoting or inhibiting religion in any way, so it went undecided. The overall decision went 8-1 in the Rhode Island statute, and it was a unanimous vote of 8-0, ruling for the Pennsylvania statute, as Thurgood Marshall did not have a vote.
Now we will both discuss our opinions regarding the ruling of the court's decision for this case.
I personally agree with the court's ruling regarding the Establishment Clause of the First Amendment and how the state statutes violated it. As the Founding Fathers had constructed the amendment and how they intended, they specifically included the separation of church and state, which was obviously violated by the statutes of Pennsylvania and Rhode Island. This excessive entanglement could allow for unnecessary state influence within our religious institutions.
I also agree with the court's ruling. Obviously, the statutes passed by both states violate the Establishment Clause of the First Amendment. And in the First Amendment, it is said that there shall be no state-sponsored religion. And in both instances, the state of Pennsylvania and Rhode Island had excessive entanglement with religion and were able to use their power, money, and influence to have a grip over religion. And in the sense, when we're talking about religious freedom, it is essential that there is that separation of state and church, because when the two get mixed up, then it starts talking about the issue of morality versus law and governance. So in order to keep these two separate, using Lemon's three-pronged test and going back throughout the case, this ruling was fair. and the court made the right decision in this case.